and invite us to pursue it in another forum. That we admit that the 6 days was illegal detention, violation of rights. Yes, we can pursue another forum in a petition, but can this court turn a blind eye when a suspect or a respondent is brought before it and his rights have been ignored, have been violated? And Your Honor, I also want you to explain the distinction why somebody who has been convicted and was in custody, the days spent in custody are used to compute the time to be served. Why can the same standard apply to those who've been in custody already for 6 days when determining their holding by the state? Because legally they only have 7 days at stake. And you're bringing the fact to the court, they've been held for 6 of the 7 that the court has given. And Your Honor, I want to bring to your attention a decision by Justice Abureli, Collins Otieno Nyango versus Republic in criminal petition number E002 of 2023, where the court invites. Sorry, but I just wanted to bring it to your attention because I've just been notified of it, and it's very relevant. Of violation of rights of a person that is brought before the court. Unless the court ever needs to say it, I'll sit down.
I don't want you to say it, but I was already have started that review. I didn't know that you are still receiving.
No, it's a decision of the court. I mean, it's the duty of my advocate, if I'm aware of a decision that is relevant to what is happening, to notify the court. But if the court doesn't want to hear it, I can sit down.
So you say it is?
Collins Otieno Nyango was Republic. Criminal petition number E002 of 2023 by the Honorable Justice Abureli. Collins Otieno Nyango was Republic. And of import in that court, Your Honor, is that if there is a violation of a right, then it is criminal petition number E002 of 2023. court was saying in this case, and the facts sit almost squarely with this one, on the question of custodial violation of rights by holding a person longer than the prescribed period. That if there was a violation of rights, even to register a charge will not be permissible. And in this case, we are telling the court, if you count 7 days from today, from yesterday, then there's an admission by the state that there has been an illegal detention for 6 days. And in light of that illegal detention for 6 days, this court is duty bound to release them. I'm still talking. Please, I'm still talking. No, please, I'm still talking. I'm explaining this decision. Please, no, please, just allow me to finish. You'll have your time. You'll have your time, please. You'll have your time. Please, sit down. These are decisions of the High Court speaking about violation of rights. And the court even proceeds to say you cannot even now register the charge. In this particular instance, they have been given 7 days. What happens to the violation of rights in the previous 6 days they've been holding them? Unless this court can only cure it by saying, we will take that into account when computing the days. But if we don't, and the court is now aware of violation of rights, then these proceedings must end at this particular point. Because what you have are persons whose rights have been violated by the state and they desire to continue violating those rights. And the court cannot be used to perpetuate that violation of the rights of the individuals before it.
Your Honor, I also wanted to seek clarity at what stage we are in these proceedings, because from what I understand, the criminal procedure is very clear that when you made a ruling, especially on the same ruling that you were asked to review, you made a final order and you clarified and you even went further and read. Now during the clarification, Your Honor, you've gone ahead and stated that you're now giving directions. I'm struggling to understand that from where we stand, where do we respond? Are we still, at which stage are we in these proceedings? Because from what I understand, we come for a review of a ruling. It has been made final. It has also been made clear that if you are dissatisfied, the best procedure is to appeal. Counsel has gone ahead in the course of you writing your direction. He is still making more arguments. He's gone ahead to mention an authority, which you also need to look at. So I think it would be good to mention that we are not in the right direction as you speak. And the best thing to do is for counsel to package his arguments in an appeal court. I think I needed to mention and correct that, because if we keep on making arguments I think we'll also come for another ruling tomorrow.
I mean, our court is allowed to interpret its directions and rulings. We are seeking interpretation in light of the facts. The ruling has been made. I have not even applied for the court to review. I have simply said, the decision has been made. We are back to the ruling of yesterday. We are seeking interpretation in light of the facts which are there. Those 7 days, we are not disputing the 7 days. We are simply saying, of the 7 days, you held them for 6.
Now
Let's
the
get
council is
directions.
aware that this is a court of law and order.
So there's what we call
it's like now we are not in a court of
interpreting
law
a
and
ruling.
order.
Interpreting a ruling is allowed. Interpreting a judgment is allowed. So we're asking the court to interpret its directions based on the facts and the decision that has been made. That's allowed. If you are not aware, I'll let you know.
Your Honor, with your kind permission, I wish to wholly associate my submissions with my learned colleague, Mr. Sonia. Your Honor, it seems that there has been a breakdown on even how parties should address the court, because Mr. Willis Otieno was making a rejoinder to my submissions, and he introduced new issues: infringement of constitutional rights, of the rights of an arrested person, and we are at a loss as to how to proceed with regards to the new issues which have been raised, which also raise constitutional issues outside Article 25A and 25B, which this court is not clothed with the jurisdiction to entertain. Your Honor, you note that the authority which has been presented before you is an authority from the High Court, which has jurisdiction to deal with infringement of rights of an arrested person.
So the point is that he needed a clarification by an interpretation by the court on the days, and he has cited an authority and they made that submission. So I give you time. I want you to respond to what you are saying. Just that then the court will give direction. So the issue is the interpretation of the days. When do the days?
Your Honor, the state had approached this court under Section 36A of the CPC, seeking an extension of the 24 hours beyond which the respondents should be held, and we had sought for 14 days. The court delivered a ruling yesterday, granting the state 7 days. Your Honor, the submissions of the state is that it was in the court's wisdom not to grant the 14 days, or it took into account the 5 days that the respondents had already spent in custody in granting the 7 days. Otherwise, the court would have been very clear yesterday and said that I've granted 7 days from the time this application was filed, and thus the respondents should not be held for more than 7 days from the time they were brought before you. So our understanding of the ruling that was delivered is that the ruling was very clear. The court took into account the time that the respondents were in custody in granting a further 7 days to the state. And the state had sought for 14 days.
I didn't wish to respond. No, but there's something you said which may influence your mind. He's mentioning that the court took into account. I mean, that's a very loaded statement. Because in your ruling that you read before us, there was nowhere the court said, I took into account. Because that presupposes.
So I don't want to put that. No, I don't want that.
Yes, I just wanted to.
Back and forth. So just leave it as that.
And also I wanted to mention the question of the decision of Justice Aburini. Even if it's High Court, it is binding on this court. So you cannot say that what the High Court said does not apply here. That's why the High Court gives directions to
So you
such
give
courts.
directions, as I told.
Much obliged.
Shule zimefungwa. And that was among the evidence that they
Soma.
Thank you so much, and poleni, network kwenye tuko network ni shida, so we try and do what we can do. But for those who've joined, thank you so much. Please subscribe if you've not subscribed to our channel, because we will be plugging you and updating you on what exactly is happening within the court, and we'll be giving you updates on many other things. But so far, please don't forget to subscribe, don't forget to follow us, and like, share also, share the stream so we can be able to give all this information in good numbers. My name is Karibu Sana. This is a live video from the courts kwenye daily trends. And of course, we want to appreciate you for joining the live. We want to appreciate you for joining the live. And this. I don't know if the network will allow me to be on the other side, but let me see. The internet will. Naomba ineti isisumbue. Nimenunua nini? Data niko nayo enough. The case is almost kicking off in a few, and we're waiting for the judge to come in. But for now, please subscribe and follow us. Don't forget to like, tafadhali. Usisahau kulike, usisahau kupenda. Okay, if you like, we are able to. So the case is about to begin, but
It is basically a natural right. In fact, some regard it as the grammar of life. No one should like to lose his liberty or battle or the wealth of the people from centuries have fought for liberty. In the Indian Supreme Court, Nuru Okanga was that the liberty is a priceless treasure for a human being. This is founded on the bedrock of constitutional rights and actuated on human rights principles. It is basically a natural right. In fact, some regard it as the grammar of life. No one should like to lose his liberty or battle or the wealth of the people from centuries have fought for liberty. Since the background of any civilized Israel, it is a cardinal value on which civilization rests. It cannot be allowed to be passed. Next to the brother, black in color, along Madaiga Road, while trying to enter house number 44. The subjects were pursued and arrested in the Soweto area and escorted to Kamukunji police station, where they were booked by OB number 41 of 9th of August 2024. Number 3, the subjects are believed to have been in the possession of hand grenades, black metal, 2 pocket phones, 7 pocket phone chargers, 3 mobile phones, and a national ID number which belongs to Elijah Karango Waibeki, and which were found inside the abandoned vehicle. Number 5, among other suspects are the Duncan Obiambo Otieno and Calvin Ochieng Dongo, who have already been arraigned in court number 3, 5 miscellaneous E27/2024. Consequently, the state required 10 days to enable the investigators cover the following areas. Number 1, subject the suspected hand grenades for bomb disposal experts for analysis. Number 2, subject the gadgets to the Communication Authority of Kenya to ascertain whether their licenses are permitted to be used in the Republic of Kenya. C, the respondents need to be interrogated by multi-agencies on the motive of the explosives due to the security danger they pose. D, that the identification parade need to be conducted on the respondents. And lastly, that the respondent place overboard is unknown. Now, the defense counsel for the respondents, led by Mr. Wilson Otieno, vehemently opposed the application and raised the following lamentations. The first lamentation is that the respondents were arrested at Dandora, Soweto from their homes. There are no compelling reasons to discuss what detention. There is no holding charge and inspect. It relied on the High Court decision of my colleague 2016. There is no holding charge, and accused should not be arraigned in court for custody orders. The second lamentation is that the respondents have been interrogated and their statements taken, and there is no further reason why they should be detained. In respect to ballistic examination, the subjects have no role to play. The third lamentation is that the state is using the court to sanitize the irregularities that they have committed, that the subjects were arrested on the 9th of August 2024, and they never arraigned in court on that day. They have been in custody for 5 days, and the investigators must have done all that they required. If they want the subjects, then someone can do. The court can order that they appear at the DCI on a particular day to assist the investigators. The investigations. The fourth lamentation is that the subjects have nothing to do with the state and the Jimmy Wanjigi. They have nothing to do with the Mudai House number 4. This is that this matter is from Jimmy Wanjigi raid, and there is a petition number E
that the court to acquiesce to the illegal detention of the respondent for 6 days and invite us to pursue it in another forum. That we admit that the 6 days was illegal detention, violation of rights. Yes, we can pursue another forum in a petition.
Nimenunua nini? And of course, the case is about to begin. To call, yes.
To the illegal detention of the respondent for 6 days and invite us to pursue it in another forum. That we admit that the 6 days was illegal detention, violation of rights. Yes, we can pursue another forum in a petition, but can this court turn a blind eye when a certain... And Your Honor, I also want you to explain the distinction why somebody who has been convicted and was in custody, the days spent in custody are used to compute the time to be served. Why can the same standard apply to those who've been in custody already for 6 days when determining their holding by the state? Because legally they only have 7 days at this point. And you're bringing the fact to the court, they've been held for 6 of the 7 that the court has given.